A temporary restraining order, I know this is going to be complicated, but it's supposed to be temporary. That's why it's in the name. Temporary, Judge. It's not supposed to last for like a month. So we don't care if this is a TRO or an administrative stay or whatever Amy Berman Jackson wants to call it tomorrow morning, whatever. It is forcing the president to do something. That is an insane thing for a separate branch of government to do. President Trump goes to the Supreme Court. You can see this is their application knocking on the door. And it involves this case involving Hampton Dellinger. Supreme Court, here's the deal. Pursuant to the rules of this court, we respectfully file this application demanding a stay. Here's why, Supreme Court. This case involves an unprecedented assault on the separation of powers that warrants immediate relief. Now, as this court observed just last term, the Supreme Court, they said this: Congress cannot act on and courts cannot examine the president's actions on subjects within his conclusive and preclusive constitutional authority. Oh yeah, we remember that from Trump versus United States, including the president's unrestricted power of removal and with respect to the executive officers whom the president has appointed. Now, as to the principal officers, of which this special counsel would be, Hampton, the most important of his subordinates, the president's management of the executive branch is one of the most important duties, including the power to remove things and people. Now, enjoining the president and preventing him from doing his job inflicts the gravest of injuries on the executive branch. Now, in the last 5 years, Supreme Court, this court has twice held that restrictions on the president's authority to remove principal officers who are acting as the sole heads of executive agencies violates Article 2, which is the executive branch portion of the Constitution. We also talked about these. SELA law versus CFBP, right? Congress said the head of the CFBP, which was Liz Warren's little janky, whatever that was, Financial Protection Bureau that was supposed to be recouping costs for Americans, but turned into a little Democrat cudgel to go after their enemies. So CFPB, Congress said you can only fire the head of that agency if they're like really bad and like they're really offensive. So you can't do it. So it's our agency. Wrong. Supreme Court said, no, that's not how this works. The president fires him. Said, okay, gone. Same thing here in Collins versus Yellen. Now, whatever the agency, for the president to discharge his duty to supervise those, the president can remove the head of an agency with a single top officer at will. Okay, it's his power. Now, on that basis, Biden fired the head of the Social Security Administration without cause. Remember that one, Amy Berman Jackson. Thus, when Trump on February 7th removed Hampton Dellinger as the single head of the office of the special counsel, right, one guy, he engaged in an uncontroversial exercise of his power. Not even complicated. Biden did it, we just did it. Since the Carter administration, the executive branch has repeatedly expressed the view that tenure protections for the head of the OSC, Office of Special Counsel, violates the Constitution. That is because the agency presents a particularly clear-cut case. They tell us they have prosecutorial decision-making power. Decisions to prosecute somebody is an executive branch power. That's what the special counsel does. That's why they're under the executive branch. Now, the Office of Special Counsel operates as literally an investigative and prosecutorial agency. They go after whistleblowers, issue subpoenas, they do all sorts of stuff. And so the president's removal, accordingly, is implicated in two preclusive presidential powers. Are the presidents, you people in Congress, are precluded from having any say in this at all, which is the power to remove and the power to control and use prosecutorial decision-making. Both the presidents, Congress is trying to usurp that. Yet within hours of the respondent filing suit and before the government even had the opportunity to respond, this judge, Amy Berman Jackson, issued an 8:35 p.m. order on February 10th and just made it up out of her booty, called it an administrative stay. I don't know, what should I do? Perfect. Let's just call it a stay. You know what that stay meant? This guy goes back into the government. That order restored the respondent to the office, okay? The president removed him. The president is elected by the people. Removed him for whatever reason, made his decision to do that. She shoved him back in. Didn't even hear from him. Enjoined any efforts to impede his access to the resources or the materials of that office. And we're like, oh, he needed to clean out his recycle bin, didn't he, on that desktop? And barred the president from installing any other person as special counsel. So then, on February 12th, the district court, again, Amy Berman Jackson, issued another 27-page opinion, which then she shifted her, quote, administrative stay. She turned it into a TRO. And then she said, again, Trump, you're banned, right? So this has more force than just a temporary stay. So the court then set the TRO to last for 14 days and specified that a hearing on an appealable order would not be held until February 26th. So you see how sneaky this is. So a temporary restraining order, I know this is going to be complicated, but it's supposed to be temporary. That's why it's in the name. Temporary, Judge. It's not supposed to last for like a month, okay, until February 26th. You issued a temporary restraining order, which is just extending the stay, okay? So she's like, well, it's temporary. Okay, well, I'll have a hearing on it when? On the 26th. 26. So this guy is in the office the entire time, doing whatever he wants to do. Trump has no power to remove him. Now, they say until now, as far as we are aware, no court in American history has wielded an injunction like this judge did. It's not an administrative stay. It's a forced act. He was fired. She's forcing him back in, not staying the firing. The firing's done. And she doesn't have jurisdiction over the firing. To force the president to retain an agency head whom the president believes should not be entrusted with the executive power, and to prevent the president from relying on his replacement. Yet the district court, Amy Berman Jackson, remarkably found no irreparable harm. Well, he already worked there, and so we should just let him work there anyways. If he's judicially barred for at least 16 days and perhaps for a month. See, and when they say, see these other rules, allowing courts to extend TROs so they last up to 28 days. So it's not so temporary, is it? And when the United States sought a stay or alternatively mandamus, so they said, wait a minute, we need to appeal this. And the reason she's keeping it as a TRO or a stay is because you can't appeal those generally. And like that's by design. So then they appealed it. And because she called it those things, she labeled it, the Court of Appeals is like, well, it's a TRO. We can't do a TRO until we're sends it all back down. So then the DC Circuit, the Court of Appeals, issued a 27-page denying relief late on Saturday night over Judge Katz's dissent, which they'll get into. So they say, look, Supreme Court, the United States now seeks this court's intervention because these judicial rulings irreparably harm the presidency. They are curtailing the president's ability to manage the executive branch in the early days of his administration. Now, as Judge Katzis observed in his Court of Appeals dissent, he says the TRO is not a TRO at all. It's an injunction against the president, and it literally requires him, like a TRO is like, okay, everybody don't change anything, just kind of keep things status quo so that nobody gets harmed. It's requiring him to reinstate an agency head who he removed, got rid of him, fired him, and she's shoving him back in. It's virtually unheard of, he said. It's usurped a core Article 2 power of the president, telling us courts may not enjoin the president regarding the performance of his official acts, regarding removal or otherwise. Otherwise, guess what? The courts become the president. Even when courts do not enjoin the president himself, this court has long held that a court will not by injunction restrain an executive officer for making a wrongful removal of a subordinate appointee, nor restrain the appointment of another, citing a U.S. Supreme Court case from 1898 that Judge Amy Berman Jackson apparently missed as she was squeezing this dude back into his office. So thus, challenges for removal have historically been litigated through suits for back pay. Okay, if Hampton Dillinger's so mad about this, he can go get his back pay. They were paying him anyways, I think. He can go complain about that, but he doesn't get his job back. He doesn't get access to his email back. There's a reason Trump got rid of him. So this court should not allow lower courts, they're going to the Supreme Court making this argument, and this is probably going to be the first of many, to seize executive power by dictating to the president how long he must continue employing an agency head against his will. Saying from Katzis, dissenting from the Court of Appeals in the DC Circuit, says, where a lower court allegedly impinges on the president's core Article 2 powers, immediate appellate review should be generally available. So we don't care if this is a TRO or an administrative stay or whatever Amy Berman Jackson wants to call it tomorrow morning, whatever. It is forcing the president to do something. That is an insane thing for a separate branch of government to do when it's the president's core power. It's articulated in the Constitution. He can do these things. The courts don't have that power. If the court does have that power, they're the president. It violates everything. And she's doing it for a reason, in my opinion, so that this guy can get in there. It's an old Democrat from the Biden syndicate, and who knows what he's in there doing. And Trump probably knows, which is why they fired him, but the judge didn't even have the courtesy to check or care. Yet the DC Circuit Court majority described waiting 2 weeks for the Article 2 power to be exercised by the rightful president is not so prejudicial because he can do a lot of damage in 2 weeks. Now, if that reasoning is allowed to stand, it's hard to conceive of any TRO Supreme Court that would trigger appellate review. Such a ruling risks further emboldening district courts to issue TROs, stopping the president from taking decisions that he is allowed to do under the executive powers. Now, that is no mere hypothetical, SCOTUS. The district court's order exemplifies a broader, weeks-long trend in which plaintiffs are challenging Trump's initiative, and they have persuaded these lower-level courts to issue these TROs that intrude upon a host of Trump's Article 2 powers. For example, a district court in New York issued an ex parte TRO, which means Trump wasn't even involved in this. Somebody ran to the teacher and said, oh, well, Trump's doing this to me, and the teacher just believed him, right? Or mom just believed, didn't ask the other kid. And turns out the other kid was right. That kid's a liar, the first one who came up there and blamed the other kid. So anyways, they went in there, ex parte, Trump wasn't even notified, saying that Trump and the entire Treasury Department be limited to, quote, civil servants precedents and be denied to political appointees. That was insane, right? That was Judge Vargas, another Democrat appointee, I think a Biden appointee, in the reckless Southern District of New York, said that you can't even allow a political appointee, like Scott Bessent. You know what his position is, obviously? The Secretary of Treasury. Judge says he can't even do anything in the Treasury. What? They also point this out. A district court in D.C. issued a worldwide TRO that prohibited the government from suspending, pausing, or otherwise preventing the obligation of any foreign assistance that was in existence on January 19th, 2025. And if I'm remembering right, I think that's Judge Carl Nichols. I think it's a Trump appointee, right? Who said, well, this could be harmful because someone might die of AIDS somewhere. Well, someone else can figure that out, right? There's other prerogatives for that. Trump's order is the order. Judge, you don't get to say, well, that order is unwise or that might have some harm or whatever. If Trump has the power to do that, you don't get to second guess him, lest you become the president, and you're not the president. Many other district courts have also issued universal TROs that sweep far beyond the parties to those cases and effectively enjoin the president's orders before agencies have even decided how to implement them. They say, look, the United States has respectfully requested that this court vacate Amy Berman Jackson's orders. The courts are trying to seize Article 2 powers from President Trump, and they're saying we can't appeal any of this in the meantime. This is ridiculous. This court should not allow the judiciary to govern and run this country by TROs and supplant the accountability that the United States Constitution ordains. Now, here's the facts. Knocking on the door of the Supreme Court asking for recourse, Trump's DOJ writes, Solicitor General says, Congress established the Office of the Special Counsel in the Civil Service Reform Act. The office began as, quote, the investigative and prosecutorial arm of the MSBP, the Merit Systems Protection Board. Congress made the agency and the office a freestanding agency in 1989, whatever the hell that means. Is in the Constitution that there's like a branch for freestanding agencies? The Office of Special Counsel remains, quote, an investigative and prosecutorial agency. It's on their own website. Okay, they prosecute people. The office executes certain provisions of 4 federal statutes. These are where they get their powers, and they promulgate regulations, and they may even bring enforcement actions, and they can require an agency head to conduct an investigation and write a report. Okay, look at how powerful this office is, they're saying. In fact, in fiscal year 2023, the office had 129 full-time employees equivalent, $32 million in funding, 4,600 cases, and more. And it's headed by a special counsel under U.S. Code. And the special counsel, as we'll note, is appointed by the president and has advice and consent of the Senate for a term of 5 years. That's under the U.S. Code, right? Trump came in and fired the dude immediately. Now, the special counsel has the statutory authority to appoint subordinate agency officials and more. So then, at some point, the Civil Service Reform Act, it says, look, you can only get rid of a special counsel. And this is the little crux of the strings that Congress tries to attach to these things. It says a special counsel, in this case, Hampton Dellinger, may only be removed by the president only for inefficiency, neglect of duty, or malfeasance. And like you got to notify Congress and then make up a reason like he's been inefficient. Oh yeah, hell. Well, because he's, someone defending the Biden crime family and covering up for their malice. However, since 1978, the executive branch has repeatedly raised constitutional objections on that restrictions and on the fact that the president can't remove this person. Carter brought it up, said this is crazy. You can't restrict the president's power to remove him. Reagan pocket vetoed a bill that would have given the special counsel more powers and more. In fact, in March 2024, though, Biden, with the advice and the consent of the Senate, put Hampton Dellinger, Hunter's ex-schoolmate, into this position. Then on Friday, he got fired. Friday, February 7, 2025, Trump came in, immediately removed him from office. On February 10th, he sued, got a temporary restraining order. Before the government could even respond to the motion, the court held a near immediate hearing. Hours later, the court entered what it called a brief administrative stay. She just made that up. That would last until midnight on February 13th. Now that order restored that guy, shoved him right back into the office. The next day, the president designated the Secretary of Veteran Affairs, Doug Collins, to be the acting special counsel. But the court said, you can't have him in there because I put my guy back. Now, the government appealed the stay to the DC Circuit. They sought a writ mandamus and they dismissed it. They said, sorry, we can't hear this. We don't have jurisdiction because it's only a stay. We can't hear stays because that's why she called it that. In a concurring opinion, though, Judge Katsas said this is ridiculous, indicated that the district court's administrative stay was not immediately appealable, but emphasized he expressed no view on the appealability or merits of any later order granting interim relief. So then, on February 12th, the district court issued what it said was a temporary restraining order. Said, until we move forward, right, the next step in this process would be a preliminary injunction. And said, Hampton is still in the office until that time. Now, in issuing that order, she found, Amy Berman Jackson, that Hampton was going to win this. And we read this and we said, totally not. not going to win. But she said he's going to win. And so that's why we're going to keep having him have access. The court acknowledged this court's decisions, recognizing they said, yeah, the president does have broad authority to remove people, but it does not extend to the office of the special counsel. So Amy Berman Jackson, the lower level judge, she identified an exception to this. She said, well, special counsels are like special, so the president can't really govern over them because of some reason. And we'll see why that's so erroneous. But that was her explanation. Now, the court stated that the office of special counsel has no authority over private actors, does not have broad rulemaking authority, or wield substantial enforcement authority. Obviously, that's ridiculous. And doesn't affect a broad swath of the American public or the economy, which is also ridiculous because you have Jack Smith, who was a special counsel, which almost took out the current president. Turning to the equities, they say, the district court, Amy Berman, accepted the contention that Hampton is going to face irreparable harm because he has an entitlement to serve as the agency head. And it said that the hardships favored him because Trump didn't explain, right? No circumstances that required the president's unexplained action that would justify the dismissal. Trump doesn't have to run it by the courts. He's lawfully allowed to do it. He did it. He doesn't have to get Amy's permission. The same day, the government again appealed to the DC Circuit. The next day, the district court denied the government's stay request for an appeal, consolidated a bunch of stuff. Then, in a lengthy opinion that was issued late Saturday, just this weekend, the Court of Appeals once more dismissed this, said, we don't have jurisdiction over this. The court said, preliminary injunctions are appealable, but because Amy is calling it a TRO, those are not appealable. Okay, so we can't hear it. It's a dumb technicality. The court acknowledged that a TRO may be treated as an injunction, but doesn't qualify here. The court said the district court is going to hold another hearing on the 26th. Meanwhile, Hampton Dellinger can just sit in his office, shredding whatever. And one judge dissented. Here's his explanation. Judge Katsas, and this is knocking on the door of the Supreme Court saying, you got to fix all this. They say the dissent was right, Supreme Court. He first explained that although TROs are generally not appealable, as everybody agrees, this TRO, which orders the president to recognize the authority of an agency whom he has formally removed, qualifies for immediate review. Like, this has to be heard now. When it comes to judicial review, courts have long recognized the special status of the president. And for instance, he cited opinions that permitted immediate review of other orders, like in the Nixon case, or in the Cheney case, or other interlocutory orders rejecting Article 2 defenses in the Trump case, with Amy Coney Barrett concurring. Judge Katsas says this happens all the time, all right? These TROs are immediately reviewable. Why? Because they're usurping a core power of the president. You have to hear this now. Now, this is Trump's DOJ's argument. They say, look, you can hear this case. You may vacate under the All Writs Act and Rule 23 of this court. You can do all of this stuff. You have plenty of power. This case says you do. This case says you do. Here's why you can grant us a victory. These factors overwhelmingly support a vacatur of the TRO. So it's like of the forced employment of Hampton. Get rid of it. Trump is allowed to fire him. Here's their argument. They say, we are going to win on the underlying issue here. The question, can the executive fire the head of the special counsel's office at will? They say the likelihood is very high. First, the court's precedents are pellucid that Article 2 empowers the president to remove at will the single head of an agency like the special counsel. Pellucid, that's your word of the day. Second, this court's precedents are clear that district courts lack equitable power to reinstate principal officers, okay? So the president has the authority to fire people, generally speaking. That's clear. We also know that the courts can't appoint people, especially principal officers. They've crossed both of those lines and precedent, and they're threatening the separation of powers, and they're doing it obviously willfully for probably some reason. Don't know exactly what it is, but I hope that Hampton's keystrokes, every single mouse movement, every single email, every single packet of information that is pinged across every server all across the fruited plain and the world are found and tracked, and we are going to reconstitute that hard drive. So Article 2 empowers the president to remove special counsel at will. Trump's allowed to do this. They say, look, time and time again, this court, Supreme Court, has held the president has unrestricted authority to remove principal officers like this guy. Article 2 says this very clearly. The president has the executive power, and the president directed to take care, capital C, which they always like to underline. It's like, well, they just are like order takers from the Congress, which they're not, that the laws be faithfully executed. The executive power includes the ability to remove executive officials. That's the CELA law case we've talked a lot about here. Now, otherwise, the president could not be held fully accountable. The buck would stop somewhere else. Well, that guy's responsible. I couldn't remove him. He did all of that. And so he's responsible for it since Congress said I couldn't remove him. No, it stops with the president. The president's power to remove those who exercise his executive power follows from Article 2, was already well settled many times. And thus the president's power to remove may not be regulated by Congress or reviewed by by the courts. Trump versus United States, U.S. Supreme Court case from 2024. Now, applying that general rule, this court, which I believe that is the Trump immunity case, which they were talking about this, right? The executive branch, the president, cannot be criminalized or dictated to when the president is doing things that the president is authorized and constitutionally mandated to do. Can't charge him with a crime, and you can't take that over and say, well, it's our job now. It's delineated to him. Now, applying that general rule, this court has repeatedly held in recent years, the president must also be able to remove at will sole agency heads like Hampton. Now, as a general matter, they say, this Constitution scrupulously avoids concentrating power in the hands of any single individual except for the president. Why? Because that is the most democratic and politically accountable official in the U.S. government. Single agency heads must also thus, therefore, be accountable to the president with at-will removal. There are only 4 single agency heads upon whom Congress has sought to confer tenure protection. We had the CFPB, Liz Warren's little thing, the FHFA, Federal Housing Finance Agency, and Social Security, and the special counsel here. The former 3 are undoubtedly subject to removal at will under Article 2, and this court's precedent foreclosed any special exception for the special counsel. So just like you could do it for CFBP, court found that in SELA law, FHFA, and Biden nuked the Social Security person, the precedent shows. How can you distinguish the special counsel from that? Because it's like a special office or something? Start with CFBP. In SELA law, the court said Congress violated Article 2. Like Congress passed a statute, but they can't override the Constitution, not without an amendment. They said, well, this guy can only be fired for inefficiency or whatever. Hey, that's ridiculous. And the court said you can nuke that guy. They did. The director was neither elected nor meaningfully controlled. The director could unilaterally dictate and enforce policy. So that's why he could be fired. This court then extended the at-will removal rule to FHFA. Look at the Collins case. Same thing here. FHFA was also led by a single director. They said the president's removal power is vital. And in short, Article 2 empowers the president to remove the head of an agency. Even Kagan was concurring in part. Then came the single head of the Social Security Administration. We're now two down. Social Security Administration also got nuked by Biden, removed him. In supporting that decision, the OLC said, well, the best reading of Collins and SELA, which nuked those other 2 agencies, should be applied here. The only courts of appeals to have considered these questions have both held that statutory restrictions, right? If you try to hamstring the executive, you violate the Constitution. So if you're going to craft a special exception for the special counsel, it's going to contravene your own precedent. How are you going to logically shove in a special counsel's office if those other 2 have to go? The Office of Special Counsel is literally, as per their own website, an investigative and prosecutorial agency. It executes 4 federal laws, and they list them. A bunch of things, issue subpoenas and depots and more. They also enforce multiple statutes. They can bring court cases. There are executive functions there. They enforce the law. Many have described them as their prosecutorial arm. Okay, lots of stuff. Look at all the stuff they do. Wow, it's a lot. Thus, the unconstitutionality of their little protection scheme has long been apparent, and the executive branch has objected to this for a long time. Carter did. Reagan did. Many others have. Public papers, Reagan brought all that up. And other precedent also opposes this. And by the way, this is not even a close call, okay? Everyone opposes this. It's unconstitutional, and so you got to go. The district court also said, Amy Berman Jackson, in her uneducated opinion, or I would say scam opinion, because it is trying to directly contravene Supreme Court precedent, said that the reason underlying SELA law does not extend to this because the special counsel is special. Well, that analysis gets things backwards, they say. This court's precedents recognizes a general rule of unrestricted removal. And even in Humphrey's executor, that other case that Pam Bondi is not going to be defending anymore, pursuant to an official memo that she sent over to Dick Durbin notifying him about that, said, we're not defending this. This case is crap. The court concluded that Congress could provide, back in 1935, tenure protections if it was like a body of experts, right? And then they narrowed that down. As long as those didn't exercise any executive power or any other functions. And so what Amy Berman Jackson was doing was trying to squeeze Hampton into this exception, which is a terrible precedent, which I think will be overturned. Second, the court has concluded that Congress could provide tenure protection to inferior officers, but those 2 exceptions represent the outermost limits of congressional restrictions, even according to the courts. Now, Amy Berman Jackson should not have asked whether the cases applying that general rule should be extended. That's not what she should have asked. Like, should we extend that to special counsel? No. It should have recognized that the rule is the president can remove people at will. That should have ended the matter, especially since the only exceptions to the president's unrestricted removal power are inapt, as in Humphreys, which is the body case, right? Aggregating a bunch of people into a board. Now, as the district court acknowledged, the special counsel is not entirely analogous to any of this. And so regardless, there's a bright line rule, they say. Adding all of this up, the Constitution prohibits even modest restrictions on the removal power. The district court dismissed Selah Law, Amy Berman Jackson, on the ground that no, the special counsel's limited. It's a small subset, doesn't have broad powers. Totally ridiculous. They say Article 2 contains no exception for any of this, exactly. For limited exercises of power for small groups, it's not in there. Well, it's not that big. It's the same argument. It's like, well, we shouldn't cancel U.S. aid because it's only 1% of the budget. Well, this is only like 1% of the cases. Doesn't matter. It's not in the law. It's not in the Constitution. Not in America's interest, so you're done. Saying, as this continues, many other administrations also have said this was a problem. Carter, Bush, but Amy Berman Jackson continues to try to squeeze this in and to shoehorn it in. And the Court of Appeals did not even review this case on the merits. And what's so bad about this is Amy's order does not just stop the president from firing the special counsel, right? The order strips the president of the authority under the statute to even remove him. So what happens if Trump says, okay, that's fine. I'll just fire him for inefficiency. I fired him at will. Now I'll just fire him for inefficiency. She says, no, you can't even do that. He now has his job. The order thus raises the prospect that even if Trump wished to fire him for cause, he would need to ask the court to do that. And that demand for judicial pre-clearance represents another intrusion onto the executive branch. The first Congress rejected the idea that the president would need to obtain advice and consent to remove someone. No one imagined that they would need to get advice and consent of a federal district court judge named Amy Berman Jackson. So at the Supreme Court, Trump continues, says, having contravened this court's removal precedents, the district court defied the remedial precedents as well. So she shoved him back into the office, even though they can't do that. She does that, undoes the president's removal decision, stops him from appointing anyone else, and puts him back in office. This court recognized long ago that the court has no jurisdiction of a bill to stop the president from doing his job, but that's exactly what she did. She stopped the president from removing the special counsel. Can't appoint anyone else. Court of Appeals didn't even listen to this, but that is no answer here. All of this is targeting Trump and his constitutional authority to govern this office. Now, whether the order is expressly directed at the president or not, it is violating the separation of powers. And he, if he wanted to complain about this, could have sued for back pay. And all of these cases explain how that works. This one, Weiner, Humphreys, Myers, all of these were suits to recover salary, to recover money, a suit for fees, and more. He can go get his money. He doesn't get his office back so he can shred the Constitution. The rule reflects the obvious Article 2 problems that arise if a court tries to reinstate him. The president cannot be compelled to have anybody in there he doesn't want. Indeed, many members of the first Congress said you can't go to the advice and consent of the Senate to remove somebody. And the court is already exceeding its powers. Reinstatement is not a remedy, never has been a remedy. Now, to be sure, Congress has sometimes departed from that equitable tradition and has empowered courts to award reinstatement. For example, they say, look, sometimes you can reinstate somebody. Like for this, Title VII of the Civil Rights Act said reinstatement could be there. And this over here in Egbert versus this case. And those principles apply to the removal of a municipal officer and apply all the more to the president's removal of a principal executive officer. All right, so we continue. Now, we're unaware of any previous case in which a court ordered reinstatement of a single agency head. Never happened before. At most, what we can find is in 1983, someone effectively reinstated removed members of a multi-member U.S. Commission on Civil Rights because that court believed that the commission functioned as a legislative agency. So something totally different. But there's no basis from applying that case to this case. And we're also identifying other factors that warrant relief, saying plainly, if the Court of Appeals holds that a president may not remove the special counsel, that alone should merit the Supreme Court's review. The court has on several occasions granted cert in heard cases to review the constitutionality of restrictions on the president's removal power. You've heard other cases before showing up on your door. That's why you should hear this one too. Like this one, Collins, Selah, Free Enterprise. Rightly so. The court has recognized that the importance of removal is a tool of supervision, and it is the key means of preserving the executive branch's dependence on the people. The expansion of the federal bureaucracy into new territories the framers could scarcely have imagined only sharpens the duty to make sure the executive branch is accountable. Yes. And further, this court, the Supreme Court, has been appropriately receptive to reviewing cases like this one where we're seeking aid of the court to protect the executive branch. And that's what we're doing now. Now, what Amy Berman Jackson has done causes extraordinary and irreparable harm to the presidency. A single district judge is forcing the president to continue allowing an officer to exercise executive power when the president, via the people, empowered by the people, thinks that that person should be removed. That sort of harm is transparently irreparable. In the first few weeks of the new administration, administration, the president is being prevented from installing an agency head of the president's choosing to implement his agenda, and the president must instead retain an agency head against his will. Not only can the district court reinstated agency head exercise executive power without being properly accountable to the president, without, for instance, the threat of removal for unwise enforcement. Now, agency heads control hiring, 100 people plus work there, and the president has lost his ability to implement his agenda completely. Now, the district court faulted the government for failing to identify the reasons. They said, well, Trump should have given us a better reason. That reasoning attacks the notion of removal at will. He doesn't have to give you a reason, Judge. Presidents may remove people for many reasons. To remove those he finds negligent and inefficient, those who exercise their discretion in a way that's not intelligent or wise, people have different views of policy get fired, those who come from competing political parties, if you've lost confidence in someone, you fire people for all sorts of reasons. And the president is allowed to do that. And it cannot be regulated or by Congress or reviewed by the courts, right? Where the courts come in and they say, well, somebody's going to die somewhere around the world, so we can't allow Trump to do that. Yes, we know, Judge, that's going to happen every day. Like, it's a big world, yeah. But the president makes decisions. He is the president, not you. He gets to decide what the consequences are and whether this is a feasible decision or not. You're not politically accountable to anybody. All you sit there and do is say, can the president do this thing or not? You don't get to weigh the harms. He's constitutionally allowed to do these things. In cases in which the executive possesses discretion, nothing can be more perfectly clear. His acts are only politically examinable, okay? And if the people are upset, then their response is, well, Rob, who's going to stop this if something goes bad? Not the courts, as long as the president is acting lawfully. If you have a problem with it because you are freaked out about transgenders not having dance performances in Ireland or whatever, then you can go and speak about that, raise a bunch of attention around your comic book problem, and bring that to the people. And then if the people are upset about it, they'll take that to their representatives, and the representatives can impeach the president. That's the proper check, not the court saying, I'm now the president and I get to substitute my judgment. The district court believed that the executive branch did not face any problems. Oh, well, we're just going to shove him back in your office there and you'll be fine with that. They say that's ridiculous. He can do a bunch of stuff. And finally, the district court also emphasized it's limited, right? So we're going to have another hearing on this on February 26th once this guy has acted as a mole and infiltrated the administration. Trump wants him gone. She wants him back on, right? It's like you have to be able to pick your team so that somebody's not working in your administration who's going to try to knife you in the throat. The Court of Appeals similarly thought that waiting for 2 weeks is great. That ignores the direct harm. The harm is happening now every minute. The president is elected for 4 years with the mandate of the people to use every minute of that. But in this case, the court has barred the elected president to stop him from controlling an entire department of the executive branch. That action alone raises grave issues of democratic legitimacy and electoral accountability. I don't care if it's limited. No one would be seriously contending that a district court's temporary order stopping the president from issuing a pardon or making a nomination or recognizing a foreign sovereign would be allowed because it's only stopping the president for 2 weeks. That's happening here too. Well, you just can't be the commander-in-chief for 2 weeks. You just can't be the president and go do this thing for 2 weeks. That's ridiculous. Indeed, history and precedent underscores the president and the nation's interest in prompt removals. The framers deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of laws, the protection of property, liberty. Accordingly, they chose not to bog down the executive with habitual feebleness or dilatoriness that comes with a diversity of views and opinions. Well, we need multiple people there to hold them accountable. No, that's what Congress is for. Very diverse, very representative of all the things. And it's a disaster. We need stuff to get done. So you don't need to have a bunch of people who are going to be knifing other administration officials in the back. Instead, they gave them decision, activity, secrecy, and dispatch so they can get stuff done. Now, consistent with that history, the court has recognized that sudden removals are sometimes necessary. 1879 case. The moment that a president loses confidence, he must have the power to remove him without delay. Myers, 1879. In that case, the court cited the prospect of delay as one of the reasons for holding that Congress could not require the Senate's consent for removal. Yeah, right, because if the Senate has to weigh it, they're just going to schedule it out, far out, and you'll have a mole embedded in the administration. The court's precedents foreclose that from happening, and we're not going to allow that here, Judge. The district court's order also threatens harm to the office of the special counsel, saying if the president had attempted to remove him, there was probably a reason for doing that, and the prospect of mass invalidation of everything done, right? Once he leaves now, like she shoved him back in, everything he's touching now is going to be tainted, and so it's actually harming the office. His appropriate remedy would be to just ask for back pay. Now, granting the government relief would not cause any harm to him. He's been removed, but he's not entitled to his job or salary. That's not irreparable injury. His reputation is not irreparable. Thus, the traditional remedy of this is for back pay. Now, the district court determined that his removal irreparably harms him because he can't do his job. But this court has rejected that reasoning too. Loss of salary is judicially cognizable, but loss of power is not. The notion that public officials have a separate private right, like a property right, to their office is an alien concept. They're not entitled to it forever. At bottom, respondents' claim to irreparable injury from being unable to continue his job is the problem. Executive power is the president's, not his. He doesn't have entitlement to the job because he wasn't elected president. If he wants it back, he can go run for president. And so you can hear this case. You can hear it, okay? We can take this right to your court. The All Writs Act says Supreme Court. You can hear it. Also, the Court of Appeals has jurisdiction over the government's appeal under this provision of the law. And so this is jurisdictional stuff, less interesting. But although Amy Berman Jackson labeled her decision a TRO, it is actually a preliminary injunction. And they already tried their administrative stay, and then they conceded that was a TRO. So she called it a stay so she could label the second proceeding a TRO. But the first thing was actually a TRO. So the second thing is a preliminary injunction. And so since we're here, we should be able to be in front of you. The court received adversarial briefing. It was sufficiently extensive. So now this is properly matured and it's knocking at your door. This case, moreover, involves the president. Here it is. The president, or in some cases, the vice president, is often able to obtain immediate appellate review, unavailable to ordinary people. Okay, so that's actually the distinction right there. That Trump was just a regular civilian when he was being sentenced in New York, but now he's the president. So Amy, accept this. The court and the precedent thus recognize that interlocutory review is sometimes necessary to protect the executive branch. Consistent with these principles, you should take it. Finally, the government asked the Court of Appeals in the alternative for a writ of mandamus. The district court's extraordinary order satisfies that, so there's jurisdiction if we go that route. The Court of Appeals also raised the concern about bad precedent, so you can settle that. Now, this case involves an order that runs against the president, and the president is not, quote, many litigants. Okay, so you don't have to worry about that. Now, Chief Justice Marshall long ago explained that in no case would a court be required to proceed against the president as an ordinary individual. Not only that, the order trenches on two of the president's conclusive and preclusive powers, the power to remove and the power to oversee prosecutions. That's at the core of his power, and they're infringing on that. Now, the government's response so far in this administration underscores the distinctiveness of this case. As noted, in the weeks since Trump's current term began, district courts, mostly in DC, have issued multiple TROs that block the president's policies throughout the nation, sometimes even throughout the world. Although the government firmly believes that these TROs exceed their lawful authorities, it has thus far sought the court's intervention only in this case because this TRO intrudes so deeply into the Article 2 powers, right? They're waiting for the best case to take up. They're going up on this one. The Court of Appeals also overlooked Hampton's own litigation conduct. Instead of awaiting the district court's judgment on his back pay claim, as many other removed officials have done, he sought a preliminary injunction because he needed to get access to those emails again. Not only that, he had obtained an administrative stay hours after he sued and a TRO 2 days later. Respondent was thus the one who created this emergency, and he cannot credibly claim that his interest in seizing the office from the presidency is urgent enough to justify the relief by the court, but that the elected president's interest in taking the department back is insufficiently urgent to justify relief. Now, if anything, it is the denial of this application. If you don't hear this Supreme Court, that would set problematic precedent. The Court of Appeals below us should have heard it too. Why? Because for apparently the first time ever, a federal court has issued an injunction preventing the president from removing an agency head and filling it with someone else. Leaving that order in place would suggest that district courts can, without appellate review, stymie any of the president's exclusive Article 2 powers for up to 28 days at maximum, and maybe longer. Now, of course, federal courts have an institutional interest in the orderly consideration of cases, but the executive branch has institutional interest too. Here, the president has an interest in his exclusive power to remove and fire people, so he can put his policies in place. The district court has frustrated those interests in a way that manifestly violates the Constitution and defies this court's precedents, and so this order should not be allowed to remain in place, not even for one more day, not much less 2 weeks. And so, Sarah Harris says to the Supreme Court of the United States, this court should vacate Amy Berman Jackson's lower-level TRO/administrative stay that granted the motion for Hampton Dellinger. Get rid of it, delete it, so the firing can be effective. In addition, the acting Solicitor General respectfully requests an immediate administrative stay of the order pending the court's consideration of this application. So 2 requests there. Get rid of it permanently, right? Just deny it, vacate it, but also while you're considering this, like, and actually mulling this over, how about you just stay it right now so that we can kick this guy back out and turn off his emails, as he undoubtedly is rummaging through right now to clean out the wreckage.